Hi, we're Keith Heidman and Jeannie Baker, patent attorneys at the firm of Quarles Brady in Wisconsin. We work with clients every day to help decide who should be listed as an inventor on a patent application, and we're here today to explain some of the rules to you.
We say rules because inventorship is governed by strict rules. It's important that the list of inventors submitted with a patent application be accurate and complete. A U.S. patent application that fails to properly identify the true inventors is invalid. Further, an error in inventorship can lead to disputes regarding who owns the patent, because U.S. law invests initial ownership of a patent application with the true inventors. I need to mention here that an error in inventorship, for example, if the claims change and we need to look at someone else's contribution, can be and frequently is corrected under the specific procedures provided by law.
It is the claims of a patent or patent application that define the invention, which is the subject matter that is legally protected by a patent. So determining proper inventorship is based on the specific elements recited in the claims. If the claims change, inventorship may change.
So, who should be named as an inventor? Under the law, the inventors are the individual or individuals who were involved in the conception of every feature described by the claims. Conception is the mental process that results in the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention.
The conception of the invention, which is fundamentally a mental process, is often contrasted with the reduction to practice of the invention. Reduction to practice means showing the invention in a physical or tangible form, either as an actual reduction to practice or by describing it in detail in a publication, such as in a patent application. In most situations, reduction to practice is not considered part of the conception of the invention, because once the invention is conceived, it often can be readily reduced to practice by one or more individuals of ordinary skill in the art, working under the direction and control of the inventors who conceived of the invention. For example, the conception of a diabetes treatment might be the idea to treat patients with a particular medication that has never been used for diabetes treatment before. The conception would include direction about dosage, appropriate patients, and possible therapeutic outcomes. Reduction to practice in this scenario may not have any inventive contribution because the invention has already been conceived. Therefore, in a scenario such as this, individuals who are working under the direction and control of the inventors are not themselves considered inventors.
However, in some situations, activities related to reduction to practice may be relevant to inventorship. These situations occur when such activities are necessary to facilitate the conception of the complete and operable invention. For example, if there were significant challenges in actually reducing the invention to practice, such as a number of failed experiments or the production of non-operational prototypes, an individual who offered suggestions or ideas that ultimately led to successful operation of the invention may be considered an inventor, because she did in fact contribute to the conception of the complete and operable invention.
Here are some fundamental principles to keep in mind. Any individual who conceived of an element of at least one claim is an inventor. So one doesn't need to contribute to all the claims, just to one of them.
Co-inventors need not have contributed equally to the conception of the claim's subject matter. Contributing to the conception of a single claim is sufficient.
Although some sort of collaboration must have taken place among co-inventors, they need not have worked together physically or at the same time. Indirect communication, such as through another co-inventor, is sufficient to establish the required collaboration.
Co-authorship of a paper describing the invention does not necessarily indicate co-inventorship. Authorship is governed by different rules.
When claims are amended or canceled during the pursuit of a patent, inventorship should be re-evaluated to take into account any changes to the claims. An individual who contributed only to the conception of a deleted element or a canceled claim is no longer an inventor. Potential disputes over inventorship can often be avoided or minimized by encouraging good record-keeping practices. Technical notebooks should be regularly updated, and records of invention should be signed, dated, and witnessed. When inventorship is determined, a memorandum may be prepared outlining who conceived of which specific elements. This will simplify the inventorship determination when claims are amended or in subsequently filed related applications.
In summary, inventorship is a legal finding, and that means lawyers are involved. It's based on the facts of each individual case, and inventorship errors can have serious consequences. If there is any doubt regarding who the inventors are for a given patent application, you will want to have a patent attorney who is experienced in determining inventorship, review the facts, and make the final determination.